You're thinking of buying a property with another individual or a group of individuals, and you're trying to figure out how you should own the property. I'm Darren Findling of QuietTitle.com, and there are a variety of ways that you can own a piece of property. In Michigan, there are a few different ownership structures that you can have. And I'm not talking about owning it in the form of a trust or a limited liability company or corporation. That'll be a discussion for another day. I'm talking about when individuals want to buy and own a property together. Let's explore each of them. The first we're going to talk about is tenants in common. This type of ownership interest is when more than one individual own the property. So we've got two people owning the property. Now, in this particular case, each owns, if there's two of them, 50%. And of course, if there's three, each would own a third. Upon the death of any of them, then that interest would go into their probate estate. It does not go to the survivors of that ownership interest. So if there's two people in this scenario, two people as tenants in common, each owns 50%, each has the right to convey out that interest at any time during their lifetime, and most importantly, upon the death of one, their 50% goes into their probate estate. Now that often is not what people intend to do. So it's critical that you discuss this and decide in advance of getting the deed, because in Michigan, if you fail to identify the type of ownership, the default provision is tenants in common. And of course, this causes all sorts of probate related concerns and issues upon the death of one of the two owners. Another form of ownership is called tenants by the entireties. This occurs when a husband and wife own a property together, when they purchase a property together. Husband and wife own it, each of them own it collectively, the whole, and upon the death of one, the survivor takes. No need to go to probate to convey, for example, the husband's interest upon the husband's death. The wife automatically takes by operation of law. Upon the second to die, that interest would then go through probate. So of course you'd want to do some planning in advance of that potential occurring. Another type of ownership is called joint tenancy. And in Michigan, we have joint tenancy and joint tenancy with full rights or survivorship. I'm not going to go into the critical details of the difference between those two, but most importantly, with a joint tenancy, upon the death of one of the two owners, the other holds 100%. This is a survivorship right of that individual upon the death of one. No need to go through probate upon the death of the first, but upon the death of the second, probate would be required. Now, with a joint tenancy, the two together have an undivided interest in the whole or in the entirety. So they don't own it 50-50, they actually own 100% together. These types of ownership issues are critical when you buy a property, and the decision about how you should own it should occur early on when you're acquiring the property to ensure that you own it in the correct way. If you've got a question about ownership and title, give us a call at 877-YOUR-FIRM or visit us at www.QuietTitle.com.